Hello friends, in the series on the income tax cases, today we will discuss a very different type of matter which is based on the benefit of principle of mutuality. First of all, it is necessary to understand what is the principle of mutuality. In some cases, there is a need for the members of our society that they form a group and they contribute some amount to some common fund, and that fund is used for their benefit. For example, people are living in different colonies, societies, and for the betterment of that society, for the security of that society, for the cleanliness of that society, they contribute a equal amount from all the members, and that amount is used for the benefit of that society. In that case, if the contributors to the fund and the participants of that fund are the same and there is a complete identity between the same, then that income of that fund is not taxable. This is broadly the principle of mutuality. This same thing also happens in the various clubs which are formed for the entertainment of the people, for their refreshment or for their recreational activities. Now, the matter was before the Ahmedabad ITAT bench in the case of Rajpath Club Limited versus Assistant Commissioner of Income Tax and another, which was reported in 113 ITR Tribunal Short Notes 45. And the moot question before the tribunal was that whether for the benefit of principle of mutuality, there should be complete identity between the contributors and participants of funds. The facts of the case are like this. There is a club, Rajpath Club Limited. There were members in the club. There was a air-conditioned hall in the club and there was a lawn in the club. This air-conditioned hall can be used by the members as well as by the non-members. Similarly, the lawn can be used by the members and the non-members. It was a very usual practice that the non-members of the club were also booking that lawn and air-conditioned hall by taking the shelter of the name of the members. When this hall was booked, it was booked in the name of the non-members, and whatever the payment was due for the use of that air-conditioned hall and club facilities, the payment was to be made by the non-members, but the primary responsibility of making the payment was of the members. For example, if some non-member books the club and he does not make the payment or create some dispute, then in that case the member was eligible to make the payment. But it was very clear from the facts of the case that the payment was being made by non-members, and secondly, the non-members were not contributors to the fund. In the earlier years, when this matter was before the tribunal has given the decision in favor of the assessee that there was principle of mutuality, but the fact that the payment was made by the non-members was not brought to the knowledge of the tribunal. That was the decision was given in the favor of the assessee. But in the present case, this fact was brought to the knowledge of the tribunal that the payment is being not made by the members but by the non-members, and the non-members were not contributors to the fund. So the tribunal held in this case that there is no doubt that the payment is being made by the non-members, and the members were only the name lending persons and they were being used as a conduit to book the hall and the lawn. So in the present facts and circumstances, it cannot be said that there is a complete identity between the contributors and the participants of funds, and the principle of mutuality does not apply in the present case. So the benefit cannot be extended to the assessee. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Rajpath Club Limited versus Assistant Commissioner of Income Tax and another. And this case has been reported in 113 ITR Tribunal, short notes 45. And the matter has been decided by Ahmedabad ITAT A bench, and the date of the judgment is 28th June 2024. Thank you, friends.